So thank you, Alan and Irina, for joining us. Maybe we'll start with just quick bios, if you guys don't mind just giving your background to the audience.
Sure. I'm Irina Ridley. I'm the Chief Legal Officer of Aaron Medical. I have been in healthcare my entire career, cut across a couple different areas. Device, most recently, I've been in diagnostics, I've been in digital health before digital health was actually a thing. And I remember talking to the FDA about what exactly is digital therapeutics as we were trying to coin the term, and been in biotech. So been a little bit all over the place. I guess I'll go back and so I have a JD MBA. Always knew I wanted to be a lawyer. Always knew I wanted to be in house. Always thought that lawyers really couldn't speak to the business, and the business didn't really understand what lawyers had to say. So tried to figure out how to bridge the gap, and have spent my career doing a little bit of that. So glad to be here.
Okay, thanks. I'm Alan Carlton. I'm a Division General Counsel for Medical Devices at Fujifilm. I've been with Fujifilm for about 6 years. They have a number of medical device companies: ultrasound, medical imaging, X-ray, and medical informatics. Most of my career was spent in-house at a company started off as called U.S. Surgical. A lot of folks in the medical device industry, if you've been in the industry a long time, company may be familiar to you. I spent 20 years with that company, supporting its medical device businesses, and in the last 4, 5, 6 years of it, I guess I was leading the legal department for that surgical device business, a global business. And then I migrated some to a company called Smith & Nephew. A lot of folks in the industry may be familiar with Smith & Nephew. I was chief counsel to their small durable medical equipment subsidiary. And then spent some time in a couple of other device companies, and one adjacency where I was compliance officer for a company that audits healthcare claims for health insurance companies. So a little bit of a diversion there. And that's my history.
Great, thanks both. Well, I'll jump right in here with our first question. We have a couple of questions we prepared, and if anyone has questions that they'd like to ask, feel free to raise your hand. And I know Amanda's also monitoring the chat for questions, Nate. So we'll watch for those. So for both of you, I will toss this question out. Given the increased focus on compliance and risk mitigation in M&A transactions, how do you see the role of legal counsel evolving during the due diligence process? There's a second part to this question, which I'll ask in a moment. So again, just kind of like as things are evolving in terms of new safe harbors, new things to look at from FDA, we got cyber security risks seemingly increasing. You know, how does your role as legal counsel, how has that evolved in the diligence process?
I'll just start off on the diligence process. I think that probably traditionally legal will sort of quarterback the due diligence effort, and then actively engage in some of the diligence like corporate governance and things of that sort, and then partner with HR on employment due diligence, with our regulatory and quality in terms of FDA and other regulatory issues, due diligence, and finance and such. I think that with the increasing evolution in terms of enforcement and focus, legal's role as quarterback is really moving to partnering, more active partnering. So certainly I think we still serve as a focal point to organize the diligence effort and pull it all together. But also I think we serve now as a more active partner, particularly with our regulatory teams, certainly with our employment teams, to help go through the material and identify where the red flags might be and work with our partners.
I think that's exactly right. And I'll just add, you know, I view this similarly to how I view the legal function across the board for an organization. And one of the things that I often tell my business partners is, please involve me early and involve me often. You know, I think it's with the evolving infrastructure and landscape, I think it's even more important that legal plays a pivotal role in that process. And you know, these things move fast, and you never want to be the gating factor. So the earlier you're involved, the more you know, the more you can help, the more you can kind of ask the right questions along the way. I've been fortunate enough that I've actually, you know, led a lot of the BD efforts for many of the companies that I've worked for. And I think it's just been super helpful because again, I can learn the business that we're looking to, take over or partner with earlier. And having that understanding of the business allows me to ask the right questions and allows me to bring in the right people earlier in the process so that they can ask the smart people can ask the questions.
That makes great sense. Just to follow up on that question, maybe I'll start with you, Irina. You had mentioned that things are evolving and there's a lot of technical aspects to all of this. How do you all stay on top of this? I'll just ask my question. Are there any specific skills or areas of expertise that attorneys should develop to stay ahead of these challenges? Again, I know personally, just seeing from Paul's presentation, there's a lot of big names in the news when it comes to breaches and whatnot. I'm not sure where I would begin if I were to try and attempt to uncover all of those things before they happen. I guess Paul would know better than I would, but it seems like kind of a daunting task.
I think that going back to my previous comment, I think it really is important to have a little bit of that operational expertise to be able to get into the business and understand what they're doing so that you know what questions to ask and so that you know what you don't know, right? And at that point, you bring in the right experts to ask the real questions and understand the subject matter. But I think it's, of course you have a good diligence checklist. Of course you have a set of questions to ask, but actually being able to understand, some of those answers and understand what it is that the business that you're acquiring or that you're working with is trying to do allows you to really dig a little deeper, ask more questions, and again, bring in the right experts.
That makes a lot of sense. And Alan, love to hear what you have to say. I was just thinking one thing that you mentioned about that you brought into the business early and often knowing what they're doing. So if maybe they say, we're going to start collecting patient data, we're going to put it in the cloud, it's going to be resident on this device, then you start to think, okay, I've heard about this, that, and the other thing. I have these data points. So I'm going to start to dig in. I remember, if that's a fair assessment, I remember, I don't remember if it was in a movie or something I saw, but they're talking about a general counsel's role. It's in a book I think I read. And they said, some really boring ones. They said the general counsel's job is to be able to look around the corner for trouble before it comes, which is obviously impossible unless maybe you have a mirror. But that kind of goes to your point, like you maybe are starting to anticipate risks before they even occur.
That's exactly right. And that's spot on, right? You understand that they're collecting patient data. Well, maybe you didn't realize that before. So you bring in the privacy people, you bring in IT, you make sure that you're looking at the infrastructure that you otherwise wouldn't have looked at because that wasn't a risk that you initially saw. So really kind of understanding and trying to get as far behind that corner as you can is critical. And it's not always that easy. And sometimes, you ask one question and it kind of spirals and you learn more and then you are on a totally different path that you initially anticipated being on. But being involved in all of those conversations allows you to pivot as you need to because there's a lot of pivoting that happens in the process.
Thank you, Alan. I think you had some comments.
Yeah, I mean, I would build on that. I think that as we know, questions and gender questions build one on top of the other. And I think that, it would be helpful and important not to silo too much the due diligence process. So for the very reasons that have been mentioned, some of the information may be gathered by the individual disciplines, be it HR, be it information security, be it finance, and they'll look at it from their agenda. But if legal is at the table with them, we can bounce each other's ideas and questions off so we can anticipate where are the potential risks that we're seeing or that might be uncovered in the course of the due diligence. In terms of specific skill areas, I think that obviously we've talked about HIPAA here. I think that certainly, as the earlier presentations also emphasized, HIPAA, if we're dealing with patient data in connection with the target company, is a growing and ballooning area for enforcement, very high stakes, very costly, and constantly evolving. So certainly that's an area that if you don't have it today, it's something that you might want to consider building some expertise, at least an ability to understand the basics and then bring in an expert to assist if you don't have the expertise. couple of other areas that I think are similarly sort of ballooning or growing in terms of enforcement activity that we might want to consider having or developing some skill sets and at least working understanding is in the area of OFAC and BIS, Bureau of Industry and Security. There's a lot of trade embargoes in the US now, growing sanctions, very costly, for example, on the import side. And so that's something that you might want to develop some expertise in and skill set in if you don't have it, and obviously the FDCA. And then I would suggest as we look through all the due diligence we've talked about, also see if you can discern patterns, not just red flags, isolated red flags, but if there's small things that are seeming to pop up in a number of places that might uncover as something of a pattern that could create a bigger vulnerability.
Thank you.
Mark?
Yep. Got a question?
I'm not sure.
Sure.
Well, I don't know if it's on. What's the threshold for, or what are the factors that come into your mind or your feelings when you just don't see it in the company? And that means the expertise, whether it be substance or legal, it kind of triggers you to say, maybe we ought to seek help. I mean, you said you were sitting around with people and calling in people from the company. There must be something in your experience that tells you we don't have it here today to solve a problem and probably should seek other expertise.
Well, so, I mean, internally, right, depending on how, I think it's a little bit of a feeling, right? You're asking questions and you're getting answers and you don't know what to do with them. And I think, certainly from my perspective, these are big investments. These are big, risks potentially. And so you want to make sure that you're bringing in the right experts. And if, depending on the size of my organization, if we have somebody that's, a privacy expert, then, I've worked with them in the past and I know what they've set up in terms of infrastructure at our own organization, then I know I can rely on them to evaluate another organization. If, we don't have that, then I will certainly look to bring someone in. Same thing across, whether it be regulatory, whether it be clinical, whether it be, commercial. I think that question also kind of, the bigger risk I see is if we're having those conversations and if we're trying to ask the questions and the other side doesn't have the answers. I think that's the bigger risk, and that's not necessarily bringing someone in to understand the gaps there. I think that's a big red flag for us as to whether or not we proceed with further conversations. So I think that's, for me, I know my organization well enough to know where we have expertise and where we have gaps, I think, for the most part. But it's really, I think the bigger, to me, challenge and risk is if we're hitting, dead ends and barriers on the other side and not being able to get the questions that we want answered or not being able to ask the right questions from that side.
Yeah, I think I'd certainly agree with that. I think that if the target is, and if they're a small company, there's a good chance that they will be pretty light in terms of internal expertise in some of these areas. That may be a signal that those are areas that you want to take a much deeper dive on to see how the company is managing those risks and if there are issues that we need to deal with. One other quick point in terms of the bringing legal in early and on the due diligence of the various areas. Obviously, diligence is to uncover risks, and so they can be evaluated, might affect the price, might even affect the decision to acquire it all. But also, if things go as hoped for, at the end of the process, your company, if you're the acquiring company, will own a new company. If you're seeing red flags, and these are potentially risks that could pose civil liability or even criminal liability, knowing that you might want to assume those risks after the acquisition, having a legal at the table early will enable you and put you in a better position to avoid unprivileged communications occurring amongst your team about those risks before you delve into them. You're going to own that risk if you decide to go forward after the acquisition. And if your own team has been building non-privileged communications about it, it's just that harder to deal with that risk.
Well, and also, I mean, one, you have a roadmap to remediating those risks as you move forward. But the other piece is that, depending on what that risk is, you'll want to make sure that you have that, you may ask the question around whether or not there's sufficient insurance on, the target side to make sure that we can address any sort of risks that happen before the close. And then if there's sufficient insurance on, my side to then address the risks going forward.
Yeah, it's a really good point. I echo that too. And I'd also, in terms of insurance, mentioned for cybersecurity. Cybersecurity insurance is very expensive, and I've seen customers, large customers, beginning more and more to press their suppliers to have large coverage on cybersecurity, which is very expensive. And the insurers are looking for a lot of requirements, multi-factor authentication, a variety of things that you may not have at the target. And so even if they have cybersecurity insurance to some extent, or they don't have it at all, one of the things in terms of that insurance risk might be to take a look at them with your risk manager to see, are they positioned so that you'll be able to put them under your cyber policy, or is there going to take time and investment to put them in a position to be able to do that?
Great points, great conversation. And not to make it into an insurance seminar, but I want, there's just a pretty interesting topic. I wonder if there's an opportunity to even purchase a policy that would act as a tail for some sort of, risk you may be facing. Maybe we'll punt on that question for now, but this does kind of bring us into our next question around this DOJ safe harbor, another new one where the government's really encouraging self-disclosure. And you find something that's going on in Amanda's example, you had, kickbacks taking place among a region with reps, and you just kind of learned about it during due diligence. I think in that case, Amanda rightfully so mentioned, you really want to do an investigation and figure out what's going on there before you need to go to the DOJ. Obviously, you don't want to go to them just, hey, by the way, we uncovered this. We'll get back to you. But I'll just read the question here. So this new safe harbor seemingly creates a tension between encouraging disclosure and the potential negative consequences of uncovering misconduct. So, how far does someone want to dig? Like the question here is, how can companies navigate this balance during due diligence, and what strategies can they employ to protect themselves while still complying with the new policy? So I know like Amanda and I and others on our team will act as compliance officers for clients during times when they just need a contract person. I know that she and I, if we started to uncover some malfeasance, we would be digging really deep because ultimately we feel like we're responsible as our client who's potentially in trouble. But, I do see the point here of this tension between, encouraging disclosure and also the consequences of uncovering that misconduct. Do you have any comments on how to address that?
Yeah, so in my view, it's to the advantage of both, clearly the acquiring company, but even the acquired company to uncover issues before the closing, if there are issues there to be uncovered. I don't think it will benefit, certainly not the acquiring company, because they're going to be purchasing a liability that they're not prepared for if they have intentionally chosen not to dig too deep because they might find some bad stuff here. But even for the acquired company, there's going to be post-closing risks and liabilities if they know that there's some lurking landmine there and they're trying to divert attention from the acquiring company. That was likely to surface after the acquisition, and now there's questions of fraudulent representations, breach of representations, indemnities, all kinds of difficulties for both the acquired company and the acquiring company.
On that note, definitely make sure that you have good covenants in place and good indemnity language in the merger agreement. But I absolutely agree. I think there's certainly benefit to the acquirer to ensure that they've done sufficient work on the on the front end, but that's not always possible, right? And so there are, of course, as you start integrating the business here, you learn things and uncover things that may have seemed insignificant or may not have, really kind of come up in the process. And I think to the conversation you had earlier, and unfortunately I missed it. It's a matter of making sure that you're really investigating and understanding exactly what it is that you've just uncovered and walked into. But it's at a certain point, if they didn't disclose that as part of the diligence process, you also don't know what conversations they've had with, others, with externally with regulators. You don't know how much scrutiny they've been under necessarily, right? And so at some point, you may want to start having those conversations because it may have already started, right? The scrutiny may already exist, and you don't want to be perceived as though you're hiding something or not really disclosing something. So as long as you've really understood the risk, gone through the exercise of investigating it, making sure that you have a pathway forward, right? Make sure you have some road map to remediating it. I think you do start having those conversations because again, they may have already started long before you, and you just, that was as hidden as everything else was in the process.
Yeah, thanks. Great comments. I know, as having been a part of deals where we've uncovered things, sometimes it's like, okay, that's a deal breaker, we're done. Other times we'll just stop doing it. And I think the new, wrinkle on this is now this policy, right? Come to us and we will avoid prosecuting you. I don't know how popular that will be. I know, what were the poll numbers? Half the people, I think, said they would disclose. I don't know if half of those people are all responsible for making that decision. So, but I'm kind of just curious if you two would like to share any thoughts. I'll reserve my thoughts until maybe after you two give yours. So, Alan.
Yeah, so the question of disclosure or not disclosure, I mean, there's a lot, and the safe harbor is certainly inviting in terms of, especially for an acquirer, in the terms of trying to mitigate or even eliminate the liability risk vis-a-vis the criminal law. But the safe harbor is not going to protect you from liability in terms of civil liability. It's not going to protect against state crimes either. And so, and by making a voluntary disclosure under the safe harbor, you're also potentially making an admission, thereby really setting yourself up in terms of a liability lawsuit if there's a key TAM relator out there, or the government just, thank you for the information, now we won't go after you on the criminal, let's turn this over to OIG and we work with them and the DOJ to now pursue the civil liability, particularly, for example, on the anti-kickback side, but also other areas as well. So I think that's a tension that's not got to be considered. If there is an issue there, I mean, and the decision is maybe let's make a disclosure, there are obviously self-disclosure policies in other parts of the government as well. And it may be that you want to look at this strategically to try to have a global disclosure and a global settlement, so you get it out of, try to get it out of the way, both in terms of criminal and law and civil, if that's practical and feasible. The other aspects to that are, again, you're going to potentially assume the risk. So one of the things you may want to do is you're beginning to uncover this kind of a potentially criminal situation, is to consider whether or not, I think, to have a joint defense or common interest agreement with the target. So if that's feasible, to put it under privilege and have a more frank discussion with the target, with the acquisition, the company to be acquired. So those are some of the thoughts that I had on that.
So I completely agree with all of that. The one, the other side of it is a little bit to what end, right? Depending on what it is, right? If it's a false claims thing, or it could be something that is hugely influential in your decision to acquire the company as it is, right? It could be the full revenue driver of the company. And so depending on what stage you are in the process, the joinder thing may not work, right? Because sure. You may have to, because that may be an issue that now you're at odds with the target. But I think it's important to understand exactly, again, what it is and, how you can, depending on what stage, right, can you walk away? Or if the deal has closed and you're learning something now, and it would have drastically changed your decision to move forward with the acquisition to begin with, I think that those are different considerations, and you're going to need to figure out a path forward that you may want to disclose, but you want to understand what that path looks like and understand your timeline to achieving, to remediating that before you include other parties.
Yeah, it's quite a dance with the government, right? There's a lot of trust on both sides of that equation. I know having this some years back, but Vermont had an amnesty program around their gift ban law, and I had a client decide to kind of go along with that and tell them we did these things, only to be then fined. So it was kind of a strange amnesty program, but so there's that, right? You could go to the government and then Amanda laid out the elements that they'll consider when deciding whether or not to prosecute, but obviously there's no guarantees that they won't. And Alan intelligently talked about all the other fallout that could occur. So yeah, it'll be interesting to see where that all winds up, and I'm sure Amanda will keep us abreast on if we hear of anyone taking advantage of it in the news.
Yeah, Mark, one other quick point to bear in mind with the safe harbor is that if it's already known to the government, you're not going to get advantage. If it's an AKS issue, there's a real risk, I imagine, that there's a whistleblower out there. And if there is, the complaint's going to be under seal, most likely. So you're not going to have any way to know that the government already knows about it. So that's, I think, a big challenge in terms of making a decision to go or no go on the disclosure.
Yeah.
To the point I made earlier also, right? Whistleblower or not, there may be, the acquirer may actually know that something is happening, and if they fail to disclose the initial issue, they may have also just failed to disclose that, and so you don't quite know what the government already knows and what conversations have been had. So you want to be really careful. To your point, it's a dance.
Yeah, I'd say suffice it to say, the best thing you can do is if you've uncovered it, if you've moved forward with your transaction, shut that down and clean it up as fast as you can. Document that so you can.
One more
David,
question
comment?
about
Yeah.
that. What if you have, or how do you factor in not quite cleaned up? In other words, no releases. So people were told you're done. Some 4 out of 5 people involved signed a release or whatever document you think helps, but somebody didn't. So they can they can become a whistleblower. Of course, they all can become a whistleblower, probably, having done that. But I'm just curious about that, how you view that lack of cleanup in the transaction. Yeah, well, okay. Right. Just said, if it's been like 18 months, do you really want to go back there? But if it stands in the way of the transaction, then you do exactly that. There's just,
I mean, and one of the diligence questions is always making sure that you have every, former employee, do you have every release and,
right.
has everyone signed a release? Has everyone signed a, IP just, relinquishing all of their IP rights.
Right, yeah.
And that's part of every diligence process, but certainly if there's one, you try to chase it down maybe, or you go at risk.
Okay, all right.
Thank you, Irina. We're sharing this microphone here. I appreciate you having you back and forth. I think we probably have time for one, maybe 2 more questions here. This one relates more to cybersecurity because for me, this is kind of a fascinating subject. Paul leads our privacy and cyber practice at the firm, but I was again impressed by the number of headlines about medical device companies, otherwise, other healthcare companies, and it's an issue that's on the rise, right? Like in terms of litigation, fines, and whatnot. And now, not to put you on the spot, Paul, but how many state laws do we have that are now, since California's laws so restrictive that the federal government, the federal Congress can't pass a law that's as strict as California is, right? Maybe I'll just let you comment for a moment, and then I will ask this question.
Yeah, in terms of In terms of privacy law, we're around 21 states, 20 with comprehensive laws, and then a couple that have overlapped into, excuse me, healthcare consumer privacy too.
Okay, and it's fair to say that California's law is so strict that Congress doesn't want to pass a law that strict, and so we don't have federal legislation, so we now have 21 laws, and we're on our way to 50 different.
That's that's a way to characterize it for sure. There's a lot of nuance there. Yeah.
So I don't know, as you know, GCs within companies mining this, that just seems like a challenge. So the question here is, cybersecurity risks and regulatory compliance issues often include complex technical aspects. Everything's getting more technical. We went to law school to learn the law, not all these technical aspects, right? How can attorneys effectively bridge the gap between legal and technical understanding during due diligence? And what resources or collaborations are essential for ensuring a thorough assessment of these risks?
Sure, I can start. So I think one thing that's very important is making sure that you have a good partner on the IT security, privacy side, wherever, however that's split within an organization, and making sure that they are involved in that conversation, the process earlier, to the extent that the target company has any sort of, data considerations, if anything of that sort. I also think it's important, kind of going back to the point I made earlier, to understand what's happened. One of the gating questions is, what does the other company have? What infrastructure do they have? What policies do they have? What processes do they have? Because if that's really a mess, that is something that you should definitely, that should be a red flag. And that's something that's going to require, I think, far more diligence and far more getting into the weeds of exactly how they are working with data, how they are protecting it, how they have, what releases they have, what policies they have. So I think it's a very important area, and one that you should at least start to address pretty early in the diligence process, because I think that's one of the few areas that I think could be an absolute deal breaker if it's if there's not a way to, if you're not seeing any type of results that you want to see as part of that diligence effort. I also think that, again, seeing where they are, if they have any sort of cyber policy in place, I think that would be helpful for any pre-close issues that come up later on. I think the other part that's important is, understanding what kind of covenants you can put in place into your agreement to address any risks that may come up later in the process.
Yeah, I mean, I would agree with all that. I would also add that, a couple of things. First of all, even before an acquisition or just in the normal course of the day-to-day, hopefully legal is partnering pretty closely with our information security team as issues come up, be it a security incident where maybe some data was lost, not because of a bad actor, but just because something went wrong internally. Legal has to partner with information security in those sorts of instances to determine whether or not, if it's patient data that may have been not compromised, but lost, perhaps if it's strictly and only a security incident. You don't have a reporting obligation to the government, but you may pretend, and likely would, to your customers. And you also have to help work with the information security team to assess that is, in that example, strictly and only a security incident and not potentially a breach as well. But then looking at the target, so if you've got this good working relationship, that helps. Then partnering with your information security expert as he or she evaluates the state of security at the target. As issues come up, the legal expertise will be helpful, both in terms of, clearly in terms of 21 state laws, if you've got that command, or you may reach out to Gardner for help. HIPAA, also contracts. So if the target has contracts with their customers, and if they're post-market, if they're out there with a product, then a lot of those, certainly if there's business associate agreements, but even without that, a lot of these customer agreements are going to have cybersecurity requirements, and it might be important to take a look with your information security team to see if they're meeting their obligations to their customers. It probably won't come to the fore until there's a breach of data, but that makes the liability that much greater if they have been found to also have fallen down on their contractual obligations. So in effect, I think that the information security team have the expertise. They know about firewalls and audit controls and pings and all kinds of things that we are not going to, well, most of us, or me, are not going to know that level of expertise on the technical side, but we hopefully can partner with them, have a working understanding of those technical aspects so we understand the language, but then also partner with them for the legal infrastructure behind that.
The one thing I'll add that's spot on is you also do want to evaluate where the data is of the target company, because a lot of your contractual obligations perhaps may limit the data to being in the US, and they may be working with subcontractors who knows where. And so it is important to know where, where that data resides and what they're doing with it.
Yeah, I think that's a great point. And indeed, that especially a smaller company may not be paying attention to that. So there you have contractual issues right there too, because a lot of customers will insist in their contract that the data be held on in country in the U.S. So I agree. That's and there was one other point, but it's escaped me now.
That's great. Thank you. Yeah, we really didn't get into the OUS, i.e. international privacy law space, but obviously seen some of the headlines out of Europe with GDPR, and the fines are just astronomical. But and save that for another time. Do we have any questions online we need to address? Okay. And I think we're probably pretty close to time here, but with the few minutes we have left, anything on LOPR, AKA Chevron doctrine, is that kind of a ho-hum for y'all, or is that something boards need to be, if you're a GC online here in the audience, is that something that you all are really worried about? Or is it more like David said, it's an opportunity that we don't really know about yet? Maybe there's something related to our product or our space where we can potentially challenge something, and no one's uncovered that. It's almost like just unknown opportunities. I don't know. Any comments there?
I think it's the latter. I think we just don't know yet. I think there's, I think as with anything, it's important to notify, to give,
Uh-oh. I guess that's it.
We're back. I think it's important to provide periodic updates to the board and just kind of notify them of the landscape, of the change, any changes to the landscape, and what's happening, and kind of provide watch outs. But I don't know that there's much more to be done at this point, or at least that's how I feel.
Yeah, I agree. I mean, I think that the departure from many years of precedent in that regard has just injected a tremendous amount of uncertainty amongst all businesses and all individuals, and it's it creates angst in terms of how much can I rely on the current regulatory scheme. But that's all you've got, right? So you've got to continue to rely on it, but it gives the in-house attorneys and our reliance on our partners like Gardner, to be out there keeping an eye out for where are the regulations going to be being attacked based on LOPR, so we can again try to stay ahead of the curve.
Thanks. And I will comment for David if he allows me to. We teach law back in Minnesota at a couple law schools, and we've read a lot of FDA cases and otherwise, and I'm just not sure the judges are really going to want to dig into a lot of these incredibly technical scientific topics. So I'm not sure how much will change, but who knows? I think that's the end of our program. Thank you very much to our panelists here, and thanks for attending today.